Today, the United States Supreme Court denied cert in two bump stock cases, the case of Aposhian and the case of Gun Owners of America. Is this bad news for gun rights? Well, specifically, it is a battle loss. I agree, but I see some strategy by the Supreme Court here that I think is going to end with a resounding defeat to the ATF, but you have to look down the chessboard just a little bit, and we're going to do that in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, best-selling author, constitutional attorney, and member of the United States Supreme Court Bar. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. All right, today, the Supreme Court denied cert in two bump stock cases. That's Aposhian versus Garland and Gun Owners of America versus Garland. Garland being Merrick Garland, the Attorney General of the United States. Now, both of these cases involve what was known as the Chevron Doctrine. And I want to talk to you why I think this is a setback and a lost battle here. But the bump stock war is not over. In fact, I think it's getting set up for a massive destruction of ATF authority. And let me walk you through why I say that. You have to be a little geeky, you have to look down the chessboard, and you have to really see what's going on all across America in the entirety of the court system to see what I think the Supreme Court is thinking and why I really think the Supreme Court is looking carefully at this by virtue of all their exterior signaling. Here's the story. Let's just step back and then I'll get to specifics. Generally speaking, as you know, Congress makes the law, the president enforces the law, and the courts interpret the law. Now, bump stocks were legal. This is just a piece of plastic, makes a gun fire in a particular way, was not really a big deal. The ATF thought it was perfectly legal until you had the shooting in Las Vegas. After the Vegas shooting, the Trump administration's ATF, and it was the Trump administration that did this, basically redefined the definition of machine gun under the NFA to claim that these bump stocks somehow were machine guns, which really is an absurd legal ruling. There was a series of lawsuits brought over this. One of the aspects of this case is whether or not the Chevron Doctrine applies. Now, what is the Chevron Doctrine? The Chevron Doctrine says that if there is a ambiguous statute or there's some question about what the statute means, a administrative agency such as the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF is allowed to interpret that regulation, and courts are supposed to defer to the administrative agency's interpretation of that statute. Now, there's a lot of pushback by mostly conservatives that say this gives too much power to administrative agencies like the EPA, the FTC, the FBI, the SEC, all those different agencies to make up the law that Congress should be doing. If they want to ban bump stocks, then they need to go through and have Congress pass a law that bans bump stocks, not have the ATF, a group of unelected bureaucrats, do their dirty work. So that was the major legal component of these bump stock cases. So today, the Supreme Court, after a very long wait, and I'm going to talk why this is so important, decided to deny cert to these two bump stock cases. Now, what's interesting, though, is that we know the Supreme Court looked very carefully at these two bump stock cases because they were recalendered 20 times. That's a critical word here, recalendered. What recalendar means in the Supreme Court lingo is that any justice has the authority to ask that a case being considered for the grant of cert, meaning that a case is allowed, before a case can be heard by the Supreme Court, 4 justices have to vote to hear it. Those votes take place in what are known as conferences among just the justices. But if there is a particular case scheduled to be conferenced coming up, any of the 9 justices have the authority to ask for it to be recalendered and not considered until a future date. Now, these bump stock cases were recalendered by someone on the Supreme Court, we don't know who, but someone on the Supreme Court 20 times. 20 times. They were recalendered, which suggests that somebody on the Supreme Court, one or more, wanted the court to look at this case in some particular way at a particular time. Because being recalendered 20 times is like unprecedented, almost unprecedented. It like never happens. It has happened, but it's very, very rare. And it only occurs when there's a very special situation, which means that the Supreme Court somehow was treating these bump stock cases as a special situation. Now, here's what I think was going on here. The bump stock case involving the Chevron Doctrine is not just about bump stocks. The Chevron Doctrine applies to all of administrative agency law, not just to bump stocks. If you cut back on the Chevron Doctrine, you don't just spank the ATF. You actually spank and cut back on the authority of the entire federal government's bureaucracy. So I think what was going on here is they wanted to look to see what is the best vehicle, what case for the 2022-2023 term, which we just began, what case is the best vehicle to cut back on federal regulatory authority across the board, not just with the ATF, but with all the other agencies. The bump stocks was clearly being considered as part of this because there's no other explanation for why it would be reconsidered, or I should say recalendered 20 times, unless it was part of some greater plan being worked on by people in the Supreme Court for some long-term view of American law. So, why was it granted? Why was the cert denied? I don't know why it was denied, but here's what I think is critically telling that this is part of a bigger picture. When a case is denied cert, and there are justices that disagree with the denial of cert, it is not unusual that one or more justices will write a dissent from the denial of cert. They write a dissent from the denial of cert explaining why they think the Supreme Court made a mistake in not hearing the case, and they lay out their reasons. And that's usually a signal to judges and lawyers down the road about how to frame cases before the Supreme Court in future issues that may pop up. But what's interesting here is there was, despite this case drawing tremendous attention by the Supreme Court, as evidenced by the 20 recalenders that went on, there's no dissent. There's no dissent by any justice, including by Sam Alito or by Clarence Thomas, to the denial of cert in the bump stock cases, which tells me that even the justices that were interested in the case didn't feel they need to write a dissent from this denial of cert, which tells me they envision that something is happening down the pike that's going to make a dissent from denying cert here unnecessary because something's happening. Now, I think there's two reasons why we probably got a denial of cert here and why it's not necessarily bad. It might even turn out to be quite good. Here's why. First, I suspect that there is cases coming right now, and there are some cases out there right now, that the court's going to grant cert, and they know they're going to grant cert between now and March of 2023 that's going to allow them to cut back on the authority of all federal agencies to create law, which is what ATF did with bump stocks. Except those are cases that don't involve like a hot potato item like guns or abortion, and they feel that's the better vehicle to undercut all administrative law in America, as opposed to having to be a gun case. It's just going to be a technical case involving Medicare reimbursement rates or ERISA or some other, very geeky thing that's not controversial, and they will be able to clean up administrative law once and for all, deal with the Chevron Doctrine and probably get rid of it once and for all, but not do it in the context of guns or abortion or some other hot ticket item that's going to get, everyone freaking out and distracted by the underlying fact that Congress makes the law and not bureaucrats. That's what I think is really going on here. But now as to bump stocks is not dead. Here's why. This goes back to you have to be a geek and the smartest person in the room to look all around the American law to see what's happening to try to get a sense of where the court's going. You see, there's another major bump stock case going on in America today, and it's a really big deal. It's a really big deal. Here's why. In Texas, there is a bump stock case called Cargill. Make a note of this. The Cargill case, which I'll put a link to down below, is in the Fifth Circuit right now. A 3-judge panel in Cargill upheld the bump stock ban as being allowed under federal law. However, in June of 2022, just a couple months ago, while the Supreme Court was determining what to do this coming term, in June, the Fifth Circuit Court of Appeals, which is a very good court of appeals, I would say, on gun rights, very good on this issue, is my opinion. I think a lot of people would agree. Very strong judges down there that support the Second Amendment, in my view. Okay? The entirety of the Fifth Circuit Court of Appeals granted a rehearing en banc, which means that the 3-judge panel in Texas that upheld the bump stock ban, that decision is going to be reheard, by the entire Fifth Circuit, which is a very smart, there's a really smart intellectual judges down there, some judges that probably could be on the U.S. Supreme Court right now. They're going to be reassessing whether or not the bump stock ruling violates federal law, and they're going to address, almost certainly, questions about Chevron. So when will that case get decided? That Cargill case will be decided by the Fifth Circuit Court of Appeals sometime in the next 6 months during the 2022-2023 Supreme Court term. So here's how I think this is going to play out. Between now and June of 2023, the United States Supreme Court is going to issue one or more decisions dealing with administrative law in America that, while not specifically in those cases dealing with the ATF, it will have the effect of dealing with ATF decisions, including the bump stock case. Now, that Fifth Circuit Court of Appeals case in Cargill is very important for a very geeky reason that's going to be very important to the Supreme Court. You see, the organization that is involved with the Cargill case was founded by a famous law professor in Columbia Law named Philip Hamburger. Philip Hamburger, and I just double-checked the organization, and that he indeed is one of the founders, if not the founder. Now, Philip Hamburger is famous for his administrative law writings and his books, explaining that Congress has delegated too much authority to administrative agencies, and that these unelected bureaucrats should not be making American law. Congress should be doing so. Now, Philip Hamburger is known across the board among all legal scholars for this theory, for this idea. He's very famous in legal circles. He is involved with this Fifth Circuit Court of Appeals on the bump stock issue in the Fifth Circuit. So I think what's going on here is that the Supreme Court in 2022, 2023 is going to issue a generally applicable law or ruling dealing with administrative law generally and possibly getting rid of the Chevron Doctrine this term. At the same time, parallel path, the Fifth Circuit Court of Appeals in a case involving an organization founded by Philip Hamburger is going to, I suspect, rule in favor of the gun rights. I think it is a gun rights issue. Gun rights plaintiffs challenging the scope of the ATF to do the bump stock rule. So what's going to then happen? So then next summer, if everything goes the way I think it's going to go, we're going to find ourselves, you and I are going to find ourselves in June of 2023 with more favorable rulings that cut back on the administrative state by the United States Supreme Court. So you have more Supreme Court decisions cutting back on the scope and authority of regulatory agencies in the administrative state, which is good not just for guns, but across the board, for America and the like. At the same time, you're going to, I suspect, have a major victory striking down the bump stock interpretation by the ATF, a major slap on the ATF by the Fifth Circuit Court of Appeals by June of 2023, if not earlier. And then what's going to happen there? Then I suspect what's going to happen at that point, and this is what the interesting thing is, that the Biden Department of Justice will be stuck big time. Because the Biden Department of Justice will be the ones that will have to take an appeal seeking cert from the Fifth Circuit Court of Appeals to the United States Supreme Court. So now instead of gun rights plaintiffs seeking cert from the Supreme Court, next summer it's going to be the Biden Department of Justice begging the United States Supreme Court to take a case that strikes down their bump stock regulations. And they're likely going to have to take that appeal because if they don't, they will look terribly weak to the gun control movement, and they will just look like they're conceding the point, which can then be used all across America in future litigations. And the Department of Justice, I seriously doubt, will not ask the Supreme Court to take cert in their, what I anticipate being bump stock laws in the Fifth Circuit Court of Appeals in Texas early next year. So now, then the question is, will the Supreme Court at that point next summer agree to hear that request by the ATF and the Department of Justice to take the bump stock case, and now it's ATF DOJ asking the Supreme Court to assess the bump stock question, but the people requesting it is the Biden folks. So now it doesn't look like a gun rights case, first of all. And number two is you're taking a case from the Department of Justice, which probably you're going to have a 50, 60-page detailed, beautiful decision written by the Fifth Circuit explaining why the bump stock decision was wrongly decided. And the lawyers involved, and this is important because the lawyers who handle these cases are very important because the Supreme Court only wants to generally hear cases brought by top lawyers they can trust. The lawyers involved with that appeal out of the Fifth Circuit to them next summer will likely be some of the best lawyers in America on this particular issue of administrative law and ATF authority. So the bottom line is that yes, these two bump stock cases were denied cert. I consider that two lost battles. However, looking down the chessboard at what's coming down the pike, I think I understand where the Supreme Court is going with this. And if I were wrong on what I just said, and this was a straight up blow to the gun rights issue, I suspect we would have had a dissent from either Clarence Thomas or Sam Alito or someone else on that court that was interested in hearing that bump stock case, as evidenced by the fact they recalendered it 20 times. So don't get depressed about the bump stock denial of cert. I don't think it's a bad news necessarily. I think there's something coming down the pike that's going to be better and bigger and better for us in terms of ATF authority being cut back. But we're going to have to wait a little bit and see how this plays out. Because remember, the Supreme Court plays the long game. They're looking down the chessboard years and years, if not decades, of American legal life. And we have to sometimes wait a little bit to get to the perfect decision and the perfect vehicle for that perfect decision. And sometimes that takes time because the wheels of justice do grind slowly, but often they get to where we need them to be. And so far, so good, knock on wood, we've been doing pretty well when it comes to gun rights in the Second Amendment, but there's a lot more work to be done, and I suspect a lot more winning to be done soon and beyond. Okay, hope you learned something here. I know it was a little geeky today, but I think it's important for you to really get the inside scoop about what's going on with the bump stock case. Don't get depressed. Don't buy into the hype that's as terrible news or great news for the anti-gun movement. None of this, I think, is true. I don't think that's the sophisticated view of looking at this or the right view. Okay, but again, hope you learned something. If you haven't subscribed, I hope you do so here at the Four Boxes Diner. We'll see you again soon. The Four Boxes Diner.
Orders up. Table 2A.